G'day everybody and welcome to the Week 5 lecture for Laws 12063, Statutory Interpretation and Legal Drafting. I'm Anthony Marinax. Last week we looked at the rules of grammar and how they teach us how we can fit words together to make specific meaning and communicate that meaning to a listener or reader. Today we're going to take one step deeper and look at legal vocabulary itself. In other words, those words which are specific to the law and which often trip legal writers and legal readers up. The law is like any other field of research or field of study or field of specialisation. It develops its own language. Just about any other field of knowledge does the same thing. If you ever sit and listen to plumbers talking to one another about the job, they'll use language that you don't understand. Football players will use language that you don't understand. Defence force personnel will use language that you don't understand. In all sorts of different areas of life, there are terms that are used within that area of knowledge which are not used or are not used in the same way within the broader language. The law is no different. The interesting thing with the law, though, is that words are so central to what we do. The other interesting thing about the law is that the law matters not only to those of us who understand the law and who have studied the law, but the law matters to all members of society. So what this means is that the law may matter to people who do not understand the language in which the law is written. That's one great reason for those people to go and see a lawyer. However, you, as experts in the law, are required to have an expert understanding of legal language. Obviously, in the space of one lecture, I'm not going to be able to make you an expert in legal language. Much of it you will have picked up over your period of study anyway. What I can do in the course of the next half hour to hour is bring to your attention some of the big issues that you will find, some of the big problems that you'll find, and some of the characteristic language that we encounter in our practice as lawyers. So we're going to start by looking at law Latin and law French. We're going to look at some words that commonly cause real problems, both in legal drafting and in legal analysis. We're going to spend some time on synonyms, which sound really simple, but gee, they make a big difference to the way the law is drafted. We're going to talk about level and tone, which are extremely important in legal writing. And we're going to talk about the importance of gender neutral and culturally sensitive language. So let's kick off by talking about law Latin and law French. And to do this, we've got to start with a little bit of history. Way back when, Great Britain, or what is now known as Great Britain, was part of the Roman Empire. The Roman Empire, which stretched from Egypt right the way through to what's now Great Britain, with Rome as its centre. As part of the Roman Empire, Great Britain received Roman law, and the Romans were really legal pioneers. One of the ways that they were legal pioneers was that they actually had a code of written law. It's known as the Justinian Code. It was written in the 6th century BC. Now, the Justinian Code is really interesting because it was a written form of laws that was taken throughout the Roman Empire. The reason this is so interesting is that prior to the Justinian Code, most law in most communities came out of culture. It wasn't written down anywhere. It was just commonly understood. Of relevance to our history, if you want to go back before the Justinian Code to find a written code of laws, you're probably going to have to go back to the Old Testament laws of the Bible, and particularly the books of Exodus and Leviticus in the first couple of books of the Old Testament. which do lay out a code of laws for the ancient Israelites. Now, obviously, when the Justinian Code was written, it was written in the language of the Roman Empire, which is Latin. Later on, we had the fall of the Roman Empire, and with the fall of the Roman Empire came the onset of the Dark Ages. During that period of time, literacy was almost unknown, except among the clergy. And the clergy, of course, did most of their reading and most of their writing in Latin. Many of the church services of what's now the Catholic Church were all given in Latin. And so Latin was the language of the learned. It was the language of learning. Even after the invasion of Britain by William the Conqueror in 1066, which starts our conception of modern England, it was inevitable that Latin was going to be a big part of the writing of the law, because it was still the case that churchmen, clerics, did most of the reading and most of the writing. When William the Conqueror invaded in 1066, though, that changed an awful lot, because William the Conqueror was Norman French. So what's now England was part of an empire which had its capital in Normandy in France. As a Norman Frenchman, William the Conqueror was more interested in speaking French than in speaking Old English. And so French was the language of the court, by which I mean the royal court as opposed to the courts of justice. And so when law started to be written after the Battle of Hastings in 1066, it was inevitable that law French started creeping into the law. The third thing that led to the prevalence of Latin in our legal reading and writing was that for many years, right up until the start of the 20th century, and in fact even beyond, it wasn't actually possible to do a law degree. Universities as they were then offered relatively few degrees, and most students who went to university studied classics. That is, they learned ancient Greek and ancient Latin, and they studied the ancient texts in Greek and Latin. Eminent lawyers like Sir Samuel Griffith actually went to university and studied classics. What that means is that all of the lawyers who then finished their classics degree and went on to do an articled clerkship where they actually learned the law, all of those lawyers were fluent in Latin. Latin was a customary language for them. And so, rather than remaining as an ancient relic, Latin continued to prosper right up to and including the 20th century. This is the reason why law Latin and law French are still with us today. As modern lawyers, we still look to the past quite a bit. We still find ourselves regularly consulting cases from the 19th century and earlier. And so we are going to continue to come across law Latin and law French phrases in our practice. Realistically, of course, Latin's now a dead language, and French is a marginal language, at least in Australia. So there's no real reason for us to continue using Latin and French. And it would be lovely if I could deal with this point in this lecture by saying, just don't use it. Realistically, though, that's not possible. And you'll remember that when I spoke to you 2 lectures ago about using the Latin presumptions, the Latin maxims for statutory interpretation, I said, look, you're going to have to learn this bit of Latin and you're going to have to learn what they mean. A wide range of Latin phrases are still with us, and you have to know them. Mainly because if you don't know them, you might not understand something that you're reading or something you're writing as a lawyer. Now, in the notes I've given a range of common Latin phrases that you will probably have come across in the course of your studies over the last few years, together with their English translations. Of course, I've only given a very few. I would like to recommend to you, though, if you have the opportunity, there's a book called Lawyer's Latin by a fellow named John Gray, Gray. Now this is a British book, and I'm not prescribing it for the course, but if you're interested in having a handbook handy to help you out if you're reading an old judgment and you come across a Latin phrase, this one's a really great one. It's written, the explanations are written simply and with quite a bit of humour, and it's available through most online bookstores from the UK for not terribly much money. It's not a textbook as such, and it's only about 150 pages, so I think I got mine for about $15, so a very useful $15 for you to spend. If you look at this list, a lot of these words you're using already without thinking. Ultra vires, subpoena, seriatim, res judicata, res gestae, quantum meruit, obiter dictum, certiorari. These are phrases that you would use regularly, or that you would at least understand fully as a result of your law studies. Law French is a little bit less common in our legal writing, but we still see a fair bit of it. Estoppel, for instance, is law French. Mortgage is a law French word. Voir dire is law French for those of you who've done evidence law. A chattel, meaning a thing, is law French. So it's also important to at least have an understanding of what those common law French phrases mean. Now, having said that, you can get into a lot of trouble trying to use law Latin and law French. For one thing, if you're going to use law Latin or law French in your own writing, you have to be absolutely sure you're getting it right, because nothing will look more pompous or stupid than using a law Latin phrase and having somebody politely point out to you that it doesn't actually mean what you thought it meant. Beyond that, though, there's really no point writing in law Latin or law French unless you're absolutely sure the person reading it is going to understand. So I have 4 laws, let's call them Marinax laws, as to when you should use law Latin and law French in your writing. The first one is, don't use Latin or French if you're writing to a layperson, if you're writing to somebody who doesn't have the benefit of legal training. It just makes you impossible to understand, and if you're doing it to try and make yourself appear pompous and knowledgeable, do everyone a favour and don't. Second, I think you should avoid using law Latin or law French even when you're writing to other lawyers. If there is a suitable English equivalent, I think it's always best to use the English. Third, if you use a law Latin or law French phrase and you're not absolutely certain the other party will understand the term, do them the courtesy of providing a translation. This can be difficult because providing the translation, you may seem a little bit like you're saying, look, just in case you're too stupid to understand this, here's what it means. However, I do think on balance it's more courteous to find a polite way to simply stick the English translation in brackets. Finally, under no circumstances should you use law Latin or law French in order to try and make yourself sound educated or important. Let's move on now and talk about some problem words. Unfortunately, within the law, because we've spent so much time as a profession arguing with one another about problematic words, arguing with one another about the meaning of things when they're written down, we've identified a number of words which regularly cause confusion. I want to draw your attention to some of them so that you become more aware of them in your own legal writing and indeed in your own legal reading. The first one and the worst one is shall. Shall is a terrible word from a legal perspective, and shall should be virtually rubbed out of our legal lexicon, because it's impossible to work out what shall actually means. Sometimes shall means may, sometimes it means must, and sometimes it means will. All of those 3 words imply quite different legal obligations. So what's the point of putting a word in legal writing that doesn't actually make it clear what the legal obligation is that arises from that word. Much better to say may if you mean may, must if you mean must, or will if you mean will. You'll see from the reading list this week there's been entire articles written on the word shall, and the general consensus these days is you really shouldn't use it at all. Next one is the word such. Using the word such to specify a class of people or a class of objects is apt to give confusion. I've given an example in the notes there where you say some vehicles are no longer roadworthy, such vehicles should not be on the road. What you really mean is those. So we could rewrite the sentence to say some vehicles are no longer roadworthy, those vehicles should not be on the road. A much clearer sentence. Such sounds a little bit pompous, but the other thing is that such has another meaning. It has a logical meaning to prepare a sentence for a logical operator. The next one of my pet hates, is the use of the word same. The contractor shall collect the concrete and deliver same to the building site. There's no need for that. Use the word it. The only reason that I can see that people use the word same in that context is because they're trying to show off a bit or trying to make their writing sound more legalistic or more formal. There's no point to it. Same with the word said. Don't use the word said when you mean the. There's a couple of examples that I've given in the notes. First one is, we've decided to take on an intern this summer. Said intern will commence in the second week of December. Can much more easily be written as, we've decided to take on an intern this summer. The intern will commence in the second week of December. There's no doubt about which intern we're talking about in that context. There's no need for the word said. Some more complicated ones that you come across are the words devise, demise, and determine. You can see on the slide there I've indicated what those three words mean to somebody who's speaking non-jargon English and what those words mean to a lawyer. The reason I've got the picture there of Gough Whitlam is that the letter that was written by Governor General Sir John Kerr to dismiss the Whitlam government said, I hereby determine your appointment as my chief advisor. What he meant was, you're getting the sack. But the word determine, which might be read in that way by another lawyer, would not be read in that way by a general member of the public. So particularly when writing to members of the public, you should be cautious about using words in a legal context if you later find that, or if you realise that those words have a different meaning to a normal person speaking normal English. Next one I want to talk about is archaisms. These are awesome. You find them in all sorts of contexts. People try to use archaic words. Archaic words are usually taken by getting a group of smaller words and sticking them together to make one big fat pompous word that really needs to be written in Old English script, or else it just doesn't look right. I've got an example there that I've picked at random from an Old English case, 1791 case found in the English reports. Beautiful sentence. Wherefore, for as much as no warrant is alleged, they held the declaration to be ill. Now, what you can see there is that the words have been pushed together in a way that makes them sound pompous and important. And it was probably the appropriate way to be writing back in the late 18th century. Nowadays, pushing words together like that in archaic form really is only going to impress people with how poor your writing is. There are a few of those archaic words that you still see, and I've given the example whatsoever in the notes, where the archaic form of the word has really become something that we're accustomed to seeing in normal English. But words like heretofore, really, there's no purpose for having them in good legal writing, which is intended to be understood by other legal readers. Now let's talk about superfluous words. For some reason, in legal writing, we quite often use a pair of words which have the same meaning. Why do we do this? Well, there's two reasons. The first reason is that in times past, lawyers were paid by the word. In the old-fashioned writ system in the UK, one of the reasons that people went to a lawyer was that lawyers were the only ones who knew how to choose from among the dozens and dozens of different types of writ, which writ was necessary for a particular cause of action. And then on top of that, lawyers were the only ones who knew how to write those writs effectively and file them. So what lawyers were doing very much of back in those days, just as in the current day, was conducting their practice in writing as opposed to standing up in court. Those lawyers were paid by the word. When you're being paid by the word, there's an incentive to write a whole lot of words. So why use one word when 8 words will do the same thing? Of course, these days we're not paid by the word. Lawyers are paid either by the hour or by the function, and so there's no reason to be adding additional words. The second reason was that in times past, sometimes these words carried slightly different meanings, and where the words had been held to have slightly different meanings and the document was intended to cover both meanings, the document had to use both words. This was particularly a characteristic of what we've described in this course as the literal interpretation of documents. When documents were being interpreted literally, if there were 3 different shades of meaning imparted by 3 different synonyms, all 3 of them would have to be in there. Otherwise it could be held that there was a deliberate omission. These days, because we take a much more purposive approach to the interpretation of legal documents, we don't need that. So if there's one word that sufficiently conveys the intention of the writer, we can just go ahead and use that word without needing extras. So instead of the parties covenant and agree, we can just say the parties agree. Instead of saying the contract is null and void, we can just say the contract is void. Instead of saying this is a certified true copy, we could just say this is a true copy, or perhaps this is a certified copy. My suggestion is that you should only be using the word and as a conjunction, joining 2 separate thoughts or 2 separate sentences. If you're using the word and to give 2 different versions of the same word, look very closely at whether it's necessary or whether you can eliminate one of those words and just use the other. Alright, let's talk about synonyms now. One of the great glories of the English language is that there are often a range of different words that can be used to express what is essentially the same concept. We call these words synonyms. The thing with synonyms, though, is that they do not precisely have the same meaning. Synonyms might cover the same logical ground, but having covered the same logical ground, they might do so in slightly different shades, in slightly different shaded ways. You'll see in the notes that I've given you a short excerpt from a wonderful book called English Synonyms and Antonyms, where the author has taken the verb to state. In the course of the book, he does this with about 200 different verbs. And he's given a list of synonyms: state, assert, affirm, aver, declare, depose, testify, swear, assure, and on it goes. But he uses each of them in context to show that If you're testifying something, you're doing the same thing as stating it. In other words, you're saying it, but testifying indicates something slightly different to merely stating. Asserting is slightly different to testifying and slightly different to stating. Informing is slightly different again. Averring is slightly different again. What it means is that if we're writing really precisely, we need to think carefully about our synonyms to make sure that the synonym we use is exactly the word that we need to impart exactly the tone of meaning that we're intending to imply in our sentence. In most cases, your objective will be to write neutrally. This means sometimes legal writing can be uncreative. It might mean that it seems like you're using the same verbs over and over and over again. But what it does is protects you from inadvertently giving a shade of meaning that you didn't actually intend. If you are going to use synonyms, use them carefully. Ensure that the shade of meaning that is imparted by a particular synonym is exactly the shade of meaning that you're intending to use. What I'd like you all to do, if you have a moment, is open up a thesaurus, either a paper thesaurus if you have one or an online thesaurus, and put in any verb you like and have a look at the range of synonyms which comes up. And have a look for yourself at the fact that if you use the one sentence with 4 or 5 of those different verbs in it, the meaning of the sentence changes, the tone of the sentence changes, the effect of the sentence changes. Synonyms are important. Next, I want to move to tone and level. Tone and level are incredibly important in legal writing. Those of you who've had me in subjects previously will know, or may know, that I've had students marked down considerably for using too informal a tone in academic writing. You cannot use the wrong tone when addressing a court. There's no use using an aggressive tone when writing to a colleague if your intention is to try to open a negotiation with them. So what are tone and level? What am I talking about? Tone is about the nature of the words that are used in the sentence and whether or not they are befitting of the circumstances that the sentence is written about. If you're writing about something serious, you don't want to be chucking jokes or sarcasm into the writing. You want to make sure that if you're writing about something serious, and as a lawyer you almost always are, you're writing in language which befits the importance of the situation. Level is very similar to tone, but level is more about the audience than it is about the circumstances. If you're writing to your client, if you're writing to a layperson with no understanding of the law, there's no point using the same words and the same language that you would use if you were writing to another member of the profession or to writing to another a member of another profession. It simply won't be understood. By the same token, if you were writing to another member of the profession and you chose to express yourself in language which is simplified for someone who doesn't understand legal jargon, you may give the impression of being condescending or just incompetent. You'll find an internet link that I've listed in the course notes for this week. I really do feel sorry for the young lady who constructed this PowerPoint website, but it's become famous around the web now, and I think she's probably doing her best to live it down. This was a set of PowerPoint slides that was made by a girl named Raspberry. Raspberry was an officer, a junior officer in the United States Navy, And apparently there's a custom in the United States Navy that when somebody gets posted to a new ship, they send their new boss a short letter introducing themselves and outlining who they are, what their experiences have been to this point, and what they're hoping to get from their new posting. Sounds pretty sensible, really. Well, Raspberry decided that she wanted to be really impressive. So instead of merely sending a letter, she constructed a PowerPoint display and emailed the PowerPoint display to her new commanding officer. It was the most outrageous, informal, terribly constructed, plain old awful PowerPoint demonstration you have ever seen in your life, and I encourage you to click on the link and have a look and a laugh. To the best that I can confirm, it's the real deal. She really did send this to her commanding officer. What you can see is that instead of taking the respectful, formal tone that any employee ought to be taking with their boss, even outside a military context, she went very informally and missed the mark entirely and ruined her own credibility as a result. She's a great example, the best I've ever seen, of completely failing to match the tone and level to the appropriate circumstances. Finally, I want to talk about inclusive language. One of the things with law is that we're constantly reading things that were written a long time ago. And when we're reading those things, we could be forgiven for believing that the law was all about straight white males. The pronoun he is used as a default pronoun. They talk about men when they really mean people. Nowadays, of course, when we're writing professionally, and even when we're conducting ourselves in normal daily life, we've all been encouraged to choose language which reflects diversity, to choose language which doesn't make the presumption that we're always talking about a specific group of people. Sometimes we might use gender-specific or ethnicity-specific language in the context of making a specific point relating to that group of people. But in general, we should strive to make our language as inclusive as possible so that it can be read by people of any gender, of any sexuality, of any racial or ethnic background, any level of disability or ability, any other personal characteristics without giving offence. Fortunately, CQU has what I consider to be an excellent guide to gender inclusive language, and I'm going to put that in the readings for this week. And if you haven't discovered it already, I really suggest that you discover it now, because it's very useful not only for your work as a student, but it's a useful one to have in your kit as you move into the profession. So you can see language is important. Vocabulary is important to good, successful legal writing. Where are we at now? Well, we've talked about words. We've talked about the grammar that allows us to combine those words into complex sentences. Next week, we're going to go on and talk about legal writing in a little more general sense. We're going to be talking about the principles and practices of plain English, and in particular the 5 rules which allow us to write in plain English. You'll find that in this day and age, all of your future employers will expect you to have a solid grasp of plain English, and it's an important skill to get your head around if you haven't got your head around it already. And I'll look forward to talking to you again next week.